Hello and welcome to 3PB's Employment and Discrimination Group July Case Law Update. My name's Naomi Webber and I'm joined by my colleague Daniel Brown. This update accompanies our monthly newsletter, which this month is edited by Faisal Asman. In this brief recording, we focus on 4 of the cases summarised in the newsletter: the Court of Appeal decision of Tabidi and the BBC, and the Employment Appeal Tribunal decisions of Gould and St John's, Downshire Hill, Gwynedd Council and Barrett, and Wilson Barker LLP and Sharon. So Daniel, you're starting with Tabidi and the BBC. What happened in that case?
Naomi, this case was about a claimant who applied for one of 2 roles as a broadcast journalist. He had an interview but was ultimately unsuccessful in obtaining the post. Originally, he brought a claim of unfair dismissal, but subsequently it was amended to include a claim of direct sex discrimination. And that's really what the appeal was all about. Essentially, the claimant pointed to the fact that the successful applicants were both women. He considered that he had more experience and was generally better qualified than them. He also referred to the fact that 6 months prior to the interview, the HR business partner had sent an email to managers saying that women were underrepresented and that needed to be rectified. In addition, when the claimant received feedback on his interview performance, it was noted that the project in particular required a focus on what was called the women agenda. And the claimant asserted that it had been assumed that as a man, he was not able to engage with that audience.
And what did the ET decide?
So the ET decided that the claimant performed very poorly at interview. It found that he had failed to do any research into the role and thought he could just rely on his previous experience as a freelancer. The tribunal importantly found that the interview panel was not influenced by sex when it scored the various applicants. Accordingly, it went on to find that the claimant had not made out a prima facie case of discrimination, such that the burden of proof did not shift to the respondent in accordance with the provisions in section 136 of the Equality Act 2010. And the Employment Tribunal therefore also concluded that because the claimant had not established a prima facie case, his claim had no reasonable prospect of success, and it went on to impose a cost order on that basis. It noted that the claimant had previously been sent a cost warning letter from the respondent. Although that was sent before disclosure and there was a relatively restricted deadline, the tribunal thought that if the claimant had approached the respondent following disclosure, the respondent would have been willing to settle the case on terms that the claimant would withdraw his claim and the respondent would not pursue costs. On that basis, the tribunal made a cost order in respect of the costs of the hearing.
And the claimant appealed to the EAT. What happened there?
The EAT appeal dismissed both grounds of appeal. In the Court of Appeal judgment, there is little discussion or really no discussion of it, and the Court of Appeal effectively focused on the tribunal's decision.
So the Court of Appeal decision focused on 2 parts of the tribunal decision, the discrimination claim and the costs order. What did they say about the discrimination claim?
So in essence, the Court of Appeal was very unimpressed with the discrimination appeal. It did not, in fact, even require counsel for the BBC to respond orally to the submissions made. It took the view that the tribunal was an experienced tribunal that heard evidence from members of the interview panel, that they were professionally cross-examined. The Court of Appeal referred to the well-known comments of Lord Nichols in Shamoon, the Chief Constable of the Royal Ulster Constabulary, which makes the point that it's often simpler to focus on the reason why question rather than engaging with the issue of who is a comparator. On that basis, the Court of Appeal held that the tribunal had concluded that sex or gender was not a part of the decision. It did not form a part of the scoring that was used to select the successful candidates. Essentially, this was a case where it was not appropriate to interfere with the tribunal's first instance decision.
How about the costs order?
In respect of costs, there was something of a dispute about the scope of the grounds of appeal. However, the Court of Appeal did note that the Tribunal's view that because the claimant had not made out a prima facie case, the cost threshold of no reasonable prospect of success was met. The Court of Appeal cast some doubt on that and suggested that there might be cases where a claim may have a reasonable prospect of success, even though at trial the claimant fails to establish a prima facie case. However, given the dispute about the scope of the grounds of appeal, the case was decided on the basis that the Tribunal was wrong in its view that the respondent would have agreed to not pursue costs against the claimant if he had approached them following the expiry of their deadline. In essence, the Court of Appeal found there was no evidence for that. The Tribunal simply relying on its own experience, and that was impermissible. The Court of Appeal went on then to consider the cost issue in terms of its own exercising its own discretion, and it took the view that given the short deadline, the offer was made on the 28th of November, the deadline was the 1st of December, and the hearing was due to take place in early January. At that stage, disclosure had not taken place, and the Court of Appeal found that in all of the circumstances, costs were not appropriate.
Thank you, Dan. That was very interesting.
Naomi, I think you're going to tell us now about the case of Gould and St John's, Downshire Hill. Is that right?
Yes. This is a case where the claimant was a vicar of one of the few remaining proprietary chapels in the country. That's a church which supports itself financially, and therefore the vicar and the claimant was employed by the trustees. The claimant was dismissed in August 2016 after a tumultuous few years. He'd had ongoing marriage difficulties, which had resulted in separation from his wife, and there'd also been a breakdown in his relationship with the respondent church, including at one stage the resignation of the entire leadership team. The claimant's case was that the reason for his dismissal was the breakdown of his marriage, because of a belief within his community that a broken marriage means a broken ministry. He therefore brought claims in the Employment Tribunal for direct marriage discrimination and unfair dismissal.
And what did the ET decide?
So the ET considered many days' worth of evidence and held on the facts that the reason for his dismissal was the loss of trust and confidence in the claimant over a 2-year period. They gave a lengthy list of reasons for this, which included a finding that he had an authoritarian and controlling leadership style. He failed to acknowledge that there was a problem with his relationships with his team, even when the whole leadership team resigned. He failed to engage with processes put in place to attempt to mend relationships. And he also had public discussions about his marriage difficulties, including seeking to ostracize those who took his wife's side. There was a factual finding that there were some members of the community that held the view that broken marriage equals broken ministry. However, it was very clear, the ET found very clearly this did not form part of the decision makers' considerations when they made the decision to dismiss. Therefore, there was a clear finding that although his marriage breakdown was part of the context, the reason for his dismissal was not in any way because of his marriage difficulties, or his potential separation or divorce. The marriage discrimination claim therefore failed, and the dismissal was found to be fair.
And what did the Employment Appeal Tribunal think of that judgment?
So the Employment Appeal Tribunal did two main things. First of all, it explored whether or not marriage discrimination was possible in the context, in this type of circumstance, and then it looked at the ET's decision specifically and whether it had reached the right conclusion. In terms of whether marriage discrimination was possible, the focus was on the fact that the correct comparator in this type of claim is a person in materially the same circumstances as the claimant, but who is not married. Therefore, they found that there could potentially be a successful claim here in two different ways. Either if the behaviour of the claimant, which was a significant reason for the dismissal, would not have been a significant reason for dismissal in cases where the circumstances were materially the same, but an individual wasn't married. So in effect, they're saying that the same action wouldn't have caused a dismissal for the same action in the same circumstances wouldn't have caused a dismissal for somebody who wasn't married. Alternatively, there could also be a successful claim if the significant reason for the dismissal of the claimant was the trustee's belief that the nature of marriage is such that a vicar whose marriage is broken down or has marital difficulties can't continue in his office. However, on the facts in this case, neither of those were made out, and the appeal was therefore dismissed.
Thank you, Naomi. Shall I jump in with Gwynedd Council and Barrett?
Yes, Dan, can you tell me what this claim was about?
Yeah, of course. So the claimants were both teachers, and they were employed in a school which is referred to in the judgment as being School 1. Importantly, their employer was the local authority, the council, rather than the governing body of any school. And the council decided to reorganise the schools in its area, and that led to a decision to close School 1 and to open a new school, which is referred to, interestingly enough, as School 2. The process that was followed by the employer in this case was that the claimant should apply for jobs at School 2. They had an interview but were unsuccessful, and they were subsequently told that they would be made redundant. The claimants, through their union representative, complained that they had not been given any opportunity to make representations or to appeal against their dismissal. Indeed, they had a right of appeal under the Staffing of Maintained Schools Wales Regulations 2006. In response to that correspondence, the chair of the governors wrote back to the claimants stating that an appeal would not have made any difference because they could not change the closure of School 1. Inevitably, the claimants claimed unfair dismissal.
And what did the tribunal decide?
The tribunal looked at the case on the basis of some agreed facts between the parties. It was, of course, agreed that the claimants were not given any opportunity to make representations or to appeal. It was also agreed that the reason for dismissal was redundancy. In addition, the parties had agreed that even if the claimants had been given an opportunity to appeal, they would still have been dismissed on the grounds of redundancy. However, the Employment Tribunal found that the suggestion that the claimants suffered no disadvantage due to the absence of an appeal was extraordinary, ill-conceived, and emphatically wrong. It found that the dismissal was both procedurally and substantively unfair, essentially finding that an appeal is ingrained in the principles of natural justice. And essentially it was wrong to conflate the closure of School 1 with the inevitable dismissal of the claimants. It went on to find also that the respondent ignored what it called the established method of dealing with redundancy situations, in particular the principle set out in the case of Williams and Compare Maxim, and it declined to make any bulky reduction, stating that it was impossible for it to come up with a percentage basis on which the claimants might have been fairly dismissed had a fair procedure been followed.
What did the Employment Appeal Tribunal decide?
So there were 8 grounds of appeal, and not all of them got permission. There was also some discussion in the judgment about the regulations which are specific to Wales, and I'm not going to talk about those in this summary due to constraints of time. The key issue, and certainly the interesting issue for employment lawyers looking forward, is the employment appeals approach to the tribunal's view of the significance of the lack of an appeal and the procedure followed by the respondent, namely one of requiring the employees to apply for jobs rather than following a conventional redundancy selection process. The first line of attack from the respondent in respect of the fairness issue and the issue of the lack of an appeal was that the respondent asserted that the Employment Tribunal had wrongly applied a test of exceptionality, that is to say, it had taken the view that only in exceptional circumstances could a dismissal be fair in the absence of such an appeal. And the Employment Appeal Tribunal rejected that argument. It noted that although the tribunal had referred to exceptional circumstances, it had looked specifically at the facts of the particular case. It had referred to the general test of fairness in section 98.4, and it had taken account of the fact that in this case, the claimant had a statutory right of appeal and indeed had not been given any opportunity to make representations or to grieve about their dismissal, and they were not given the opportunity to be consulted about the procedure that was to be followed. So on that basis, the Court of Appeal held that the Employment Tribunal was entitled to find that the lack of an appeal did create unfairness, such as to lead to an unfair dismissal. The second issue relates to the procedure that was followed in terms of the claimant having to apply for jobs rather than go through a traditional redundancy selection exercise. And in that regard, it was said that the tribunal wrongly elevated the principles in Williams and Compare Maxim related to consultation and so forth to being rigid rules. The Court of Appeal rejected that and noted that the words used by the tribunal referred to the established method. The tribunal had not indicated that that was so rigid as to be unfair if there was any stepping outside of it. And in particular, the tribunal noted that in this case, the claimants were in essence being asked to apply for either identical jobs or substantially similar jobs. The vast majority of staff who worked at School 1 were not made redundant as a result of the closure of School 1. And there were things the claimants could usefully have been consulted about, perhaps not least the procedure that was used in relation to redundancy selection. And so on that basis, the Court of Appeal, the Employment Appeal Tribunal held that the tribunal's decision was essentially refused. The Employment Appeal Tribunal dismissed the appeal against the Employment Tribunal's judgment in respect of that issue. Finally, it turned then to the question of Polkey, because the tribunal had refused to make any Polkey reduction, essentially having found that dismissal was not inevitable for all of the reasons given above. The Court of Appeal, again, was not prepared to say that that was a decision that was perverse. It was open to the tribunal on the facts of this case.
Thank you, Dan. The final case I'm going to talk about is Wilson, Barker and Sharon. This was a case where a claimant had worked as a paralegal in a solicitor's firm and had brought a number of claims in the Employment Tribunal. There was a liability hearing, and following that, she was successful in claims for harassment on the grounds of age and sex. These claims had, on the face of it, been brought out of time. The last acts of age and sex discrimination had been in March and April of a particular year, respectively, but then ACAS early conciliation had not been started until August of the same year. However, neither party raised jurisdiction or time limits as an issue at any stage of the liability proceedings. After the liability judgment, there wasn't an appeal, and the case therefore went to a remedy hearing. On the first day of the remedy hearing, the respondent raised for the very first time that the claimant's claim had been out of time. The respondent submitted that as the claimant had never made an application to extend time, the tribunal therefore didn't have jurisdiction to award a remedy. As such, what the respondent was arguing was that this wasn't a challenge to the liability judgment per se, but instead saying that the Employment Tribunal was therefore precluded from awarding a remedy of any sort.
And how did the Employment Tribunal deal with this unusual case?
You're right, Daniel, this is very unusual. The judge in the Employment Tribunal accepted that the question of jurisdiction and extension of time hadn't been dealt with at any point, referred to it as an oversight. However, the judge held that it would clearly have been just and equitable to extend time, and therefore formally did so retrospectively, therefore effectively stating that the claim had now been brought in time, and went on to make an award for injury to feelings and aggravated damages.
Interesting. And how did the respondent put its case on appeal?
So the respondent appealed on all aspects, both the extension of time point and the substantive award. What the respondent said was that it should have been, the claimant should have made an application to extend time rather than it having to challenge the liability judgment.
And what did the EAT decide in relation to those grounds?
So the Employment Appeal Tribunal, on the time limit point, said that the respondent's suggestion that it was the claimant who should have made an application to extend time was misconceived. There had been a liability judgment. It found in the favour of the claimant on a number of claims, and that judgment was therefore final and binding on all the parties unless and until it was overturned. Therefore, if the respondent had thought it was incorrect, for example, because it argued that the tribunal didn't have jurisdiction, it was for the respondent to challenge that judgment by way of an appeal or an application for reconsideration. While the liability judgment stood, any argument about whether or not liability had been established was res judicata. It therefore said that the Employment Tribunal had not been wrong to retrospectively extend time, and that the liability judgment stood and a remedy could be awarded.
Naomi, were there any other points arising from that appeal?
Well, there was also the appeal of the remedy itself. The Employment Appeal Tribunal rejected the respondent's arguments that the tribunal had been wrong in principle in making an award for compensation for injury to feelings and aggravated damages. However, it did uphold the appeal against the amount awarded and remitted the issue to the same Employment Tribunal for redetermination.
Thanks, Naomi. Those are all of the cases we've got time for, and they'll be summarised in 3PB's employment newsletter for July. Naomi, are there any other events coming up that you'd like to tell us about?
Yes, thanks, Daniel. We're now doing monthly live webinars on various topics related to employment and discrimination law. This month, on the 9th of July, Catherine Anderson and myself will be doing a live webinar on religion and belief in the world. That will be available as a recording after the event as well. Also look out for further webinars coming up in August and September and beyond. Thank you very much for listening.
Thank you.